Hi, everyone. Patrick Howell here. I am a board certified construction lawyer here at Becker. Board certification just means that the Florida Bar has designated me as an expert in the area of construction law. The bill that we're going to be talking about today that was signed into law by Governor DeSantis is Senate Bill 360. That's Senate Bill 360. At the end of this webinar, you'll get my email address. If you would like a full copy of the bill to review it yourself, shoot me an email and I'm happy to provide the full text of the law as it was signed into law by the governor. Let's go ahead and get started about what this bill does. So Senate Bill 360 was signed into law, as I said, on April 13th of this year. It's a part of the tort reform measures that were pushed by the Florida legislature and also Governor DeSantis. And this bill makes changes to Florida Statute 95-11-3, which is the statutory provision that sets the statute of limitations and also the statute of repose for construction defect claims for either new construction or also renovation projects. So this webinar is going to be very important for both new communities and then older communities that are looking at renovation projects such as balcony restoration, new roofs, new windows, or really any construction project at your property. What does Senate Bill 360 do? First of all, the deadline for bringing a claim has been shortened. Senate Bill 360 shortens the time frame from 10 years, which is the statute of repose before the signing of the legislation, and it brings it all the way down to 7 years. In just a minute, I'll tell you why it's actually less than 7 years and why this is an important change. 3 years may not seem like a lot, but everybody should keep in mind that the statute of repose was 15 years just a few short years ago. So we're seeing the eroding of the timeline that a community association is able to bring a construction defect claim from 15 years to 10 years and now down to 7. So we're actually at less than half of the time frame that we had when I first started practicing law just a few short years ago. The statute of repose is the absolute latest date that a lawsuit for construction defects can be filed. In Florida, there is a 4-year statute of limitations for bringing a construction defect claim. However, if the defect is hidden, as many defects are under stucco, the membrane underneath a roof, things like that, you actually start the running of the statute of limitations upon the discovery of the defect. However, the outside limitation is the statute of repose, and that's what we're talking about here. So even if you discover a defect on year 6, the statute of repose isn't going to give you the full 4 years of the statute of limitations. It's only going to give you 1. And so that's what we're dealing with here. As I mentioned before, it applies to both new construction and also renovation projects that a community association may have. The second thing that Senate Bill 360 does, and I mentioned this earlier, it starts the running of the deadlines early. So previously, the triggering events for the running of the statute of limitations and the statute of repose. One of them was, for instance, the contract with the engineer, architect, or the contractor. So when that contract was finished up, then the statute of limitations and statute of repose would begin to run. That sort of made sense as a trigger because why would you want your statute of limitations to begin to run when you haven't even finished up your contract with your contractor or your engineer or your architect? Now they have moved the triggers to different starting events. The first of which is the temporary certificate of occupancy. So this is also known as the TCO. This is a certificate of occupancy that is given to a building in its sort of shell status. Maybe the building needs to have its electrical systems installed, the plumbing, and so the building department will give the owner of the property a TCO, temporary certificate of occupancy, to come in and put all those things in, add the drywall, the flooring. So you can see why I said that the statute of repose has actually been reduced more than just 7 years, because no owner takes possession of their home or their unit, until it's finished up. And so, with running the statute of repose, or triggering the running of the statute of repose with the temporary certificate of occupancy, you lose more time. If there is no temporary certificate of occupancy, then the statute of repose and limitations begins to run on the certificate of occupancy. So that's what's given by the building official, who says, all right, this home is completed, and the new owner can move in, everything is good to go. There's also, if you're dealing with things like roads or infrastructure, then the statute of repose and limitations begins to run when the county or city issues a certificate of completion for those roads, those sidewalks, or those drainage structures. And then the final one is if there's none of those different things, then it's the date of the abandonment of the construction. The language says that with all of these 4 different triggering events, the statute of limitations and statute of repose now begins to run at the earliest of those. The law, as previously written, was the later of those different events. And so a community association or an owner got a little more time before their statute of limitations and repose began to run, because you would look at the last or later of those different events. Now it's the earliest. So with condominiums in townhome communities with multiple buildings that are, as typical, constructed over a few different months or even years, it used to be that the status of the law, as most people interpreted it, was that when the entire project was finished up for a community association that maintains the exterior, building envelope, and all of the infrastructure, that the statute of repose began to run at the end of that. So when the final building was finished up, when the final section of the neighborhood was finished up, that's when the statute of limitations and the statute of repose began to run. This was really helpful for community associations that sometimes take years to turn over, because you got a little bit extra time in which to get organized and hire an engineer or an architect to conduct a forensic review and then file a claim or initiate a claim, if there are defects found. Now, as the law is currently written, those different buildings, as they're finished, and those different units, as they are CO'd, the statute of limitations and the statute of repose is going to begin to run on those individual buildings as they're finished up. So you're going to have communities, if they're constructed over a 5 or 6 year period, you're literally going to have communities that are turned over to the owners with buildings and units and roadways that are already barred by the statute of limitations and the statute of repose. So it creates a serious problem for community associations. You're probably wondering who was behind this bill and who supported this bill. It's developers and the contractors lobby. They're the ones that pushed this bill and had their lobbyists run this bill through the legislature. Developers did, of course, protect themselves, as they typically do. And so for their model homes and things that they're going to be showing off to folks, it may be a model unit in a condominium, maybe a model home in a neighborhood. The statute of limitations and the statute of repose doesn't begin to run on those homes or units that they keep for themselves until they actually transfer the title to the end user. They did not include any sort of exclusion for everybody else out there. So just the ones that they hold on to as model homes are excluded from those triggering events that I mentioned before. Sort of an insidious provision within this bad bill. The other thing that is very troubling about Senate Bill 360, especially in wake of the condo safety bill and all of the things that we've done to make condominium buildings safer in Florida after the Surfside tragedy, is that Senate bill waters down the private cause of action that's found in section 553.84 of the Florida statutes. What that statute does is it provides a private cause of action for violations of the building code that result in damages to the owner or the association. So this, in my litigation cases, when we've got building code violations, we are able to include a count for this in our lawsuits. And it's a very consumer-oriented piece of legislation. What this bill, it's Senate Bill 360, does is it takes section 553.84 and it waters it down by adding a materiality requirement. So before the bill was passed, if you had a violation of the building code, that was a violation of the building code. And if damages occurred as a result of that, then you were able to file a cause of action. Keep in mind, the building code is the minimum standards here in Florida. Most people expect that a contractor is going to build, their buildings or their roadways to more exacting standards than just the minimum standards. So this is a watering down of those minimum standards. And so you've actually got to show now in our cases that the building code violation has or will result in physical harm to a person or significant damage to the performance of a building or its systems. So this is something that's very troubling and is something that we hope is somehow addressed in a glitch bill in future sessions. We will see. Now, one of the questions that you probably all have is, when do these changes become effective? Senate Bill 360 took effect as of April 13th, 2023. So it's already in effect as we sit here right now. And so that materiality component that was changed, that is in existence as we sit here right now. However, they did include a savings clause within the bill that allows for any cause of action that exists before the bill was filed. You still have time to file the cause of action under the existing statute of repose of 10 years if you file your lawsuit by July 1st, 2024. You have to file your lawsuit before July 1st of next year. And so that's an important thing to remember about this bill. And we'll talk a little bit more about how your community association can protect itself, considering we do have this savings clause that was added to the bill. So let's get right to it. If you believe that you have a construction defect claim, you need to act right now. We need to finish this webinar, and you need to contact your community association lawyer or a construction lawyer like me, and you need to talk to them about that construction defect. Remember, your association has until July 1st, 2024, this is next year, to file a lawsuit under those prior deadlines. So a claim that it's viable now or is viable, viable in a month or two, may completely evaporate at midnight on July 1st, 2024. So the time now is the time is to act now. Get your engineer out, get your experts out to look at what you are worried may be a defect, and retain that engineer to prepare a report, and then consult a construction lawyer. That's for new construction. For a newly constructed community, this is how you're going to calculate. So I put some tips on the screen here to help you. You're going to want to establish when the statute of repose began to run. So if you have if you're in a new community, if you're in a new condominium community, this is what you're going to do. So first of all, see if you can find a temporary certificate of occupancy. You're going to want that for the first unit or the first home. These can be obtained from the building official. So if your community was permitted by the city, you're going to contact the city. If your community was permitted by the county, you're going to contact the county, and you're going to ask for the first temporary certificate of occupancy that was issued by the building department for the community. If you have one, then that is when the statute of repose and statute of limitations began to run for your community. If you don't have a TCO, or you're not able to find one, then pull the certificate of completion for the roads, for the drainage, or the certificate of occupancy for one of the units or one of the homes. You're going to want to look for one of the first units constructed or one of the first homes constructed. Then keep in mind that there still may be a TCO out there. There may still be a temporary certificate of occupancy floating around out there that you don't know about. So what we're recommending is that you then take that date on the CO or the certificate of completion and then count back 6 or 8 months, because that's typically when a TCO will be issued for a unit or a home. Then you're going to basically have the deadline for the running of the statute of repose. So you take the 7 years, you count back 6 or 8 months from that date, calendar that date. That's the date that you know that your community will run out of time and not be able to file a construction defect claim for some or all of its buildings or units. I mentioned this before, but if you're unable to find the TCO for the first building, then just use the count back. So in this example that I put on the screen, you're unable to find the TCO for the unit in the first building constructed in your townhome community, but you go through the property records and you find a certificate of occupancy for a unit in that building that dates to January 1st, 2020. And you look through all the others, and you figure out that that's the first one. It's the first one that you can find for the certificate of occupancy. Then count back 8 months. That takes you back to May 1st, 2019. Adding in 7 years in your approximate deadline to file a construction defect claim is May 1st, 2026. So this is an example to follow, and try to make it easy for you and just see how you would do that. Then calendar that date, and you'll know that by that date you need to have an engineering study done. You need to have retained a construction defect law firm, and they will have had to file the lawsuit prior to May 1st, 2026. Under that example that I just gave, that community has about 3 years to do all of those things. So you can see how you have to act quickly. Engineers and architects are in short supply right now in Florida because of the condo safety bill. They're being pulled in a million different directions, trying to help condominium towers that are over 3 stories get certified. And so now is the time, if you realize that you've got 3 years, 2 years, and God forbid, only 1 year, now is the time to act. Now, the question comes up, what if you perform that calculation and the deadline is only a few years out? Maybe it's a year out or a year and a half out. There's defects, you've seen them. Maybe in an HOA, you have private roads and the roads are in very bad condition. Maybe the drainage in the community is bad and there's flooding constantly. Maybe with your condominium, that the roof leaks or that the windows leak, or that there are other cracks on the exterior of your townhome unit and building. What we recommend, if you have not turned over and turnover looks to be a few years out, is to go ahead and start documenting those defects with both the management company and the developer appointed board members, and then save those emails. If you don't know who the developer appointed board members are, you can easily look that up on Sunbiz. Just look for the corporate information for your association, and you will see all of the developer appointed board members listed in each of the annual filings for the association. Then try to make contact with them. All of the addresses for that company, for that association, is going to be on Sunbiz as well, so you can send a letter. Also, when you send emails to the management company, use those board members' names and say, I would like for you to forward this on to these 3 developer appointed board members, and let them know about those defects, so that you can have documentation of that. The next thing is, in that email, demand that an engineering firm be retained to inspect the property, perform any necessary testing, and issue a report of their findings. Then also demand that report be distributed to the owners as an official record. Follow up on your email. If they have, they're required to have annual meetings, even though they're controlled by the developer, they're still required to have annual meetings. Go to those annual meetings, find out from the property manager where those are being held, and go to those meetings and ask questions, submit your questions about the defects, and document that you have done so. Remember, with an HOA, the developer is required to appoint 1 non-developer board member at the 50% sellout mark. And so find out who that non-developer person is and speak with them about when meetings are going to be held, and see if you can get the email addresses of those developer appointed board members. And then finally, reach out to a construction lawyer for guidance during this process. They may tell you, look, based on the sellout in this community, you're not going to have turnover for 4 more years, 5 more years. And by then the statute of repose will have run on your claim. And they will give you some legal guidance then as to what to do. One of the things that they may recommend that you do is actually go ahead and initiate a claim yourself, at least to protect your own interest. And it may actually protect the interest of your neighbors as well. So there are construction lawyers that can offer advice on that. I'm certainly one of them. So my email will be at the end of this presentation. So reach out to me if you're in that position. I'm happy to give you some guidance. Now, I mentioned before that the new law applies to both new communities, which we've spent some time on, but it also applies to older communities that have renovation projects. Concrete restoration projects are going on throughout Florida right now, and some of them run into the millions of dollars. Very, very, very expensive projects. A roof replacement, a multi-phase condominium that's getting its roofs replaced, it could run into millions of dollars. These are high dollar renovation projects, this law applies to them. So it's the same thing. You're going to want to establish when the statute of repose began to run, and then you're going to want to add 7 years to that date to get your filing deadline if you suspect there are construction defects. This is going to be very, very difficult now, because one of the triggers that was included in the prior law that I mentioned already was the trigger of the completion of the contract. And so for a renovation project, many times that was the date that was relied upon, because you don't always get a TCO, a CO, or a certificate of completion from the city or the county building official after a renovation project is completed. And so we would use that date, and then we knew when the statute of repose and limitations and whatnot were running. That language has been completely removed. And so we are all sort of at a loss as lawyers as to what the judges are going to do here in Florida. So in the meantime, we're thinking that the best rule of thumb is to go ahead and calendar 7 years from the date the contract is signed. And then as you start to approach that 7-year period, if you have any sort of suspicions that your roof, your concrete project, or anything else may have been done improperly or in a defective manner, contact a construction lawyer. Because with the old statute of repose of 15 years and then even down to 10 years, you really had a pretty good opportunity to see if hidden defects started to erupt. So with a re-roofing project, maybe year 6 or even 7, the roof starts to show some distress and starts to leak. You could hire an engineer or a forensic architect and then initiate a claim with your favorite construction lawyer. All of that now has been pushed up by 3 years. So you're going to have to be vigilant and calendar these and give a really close look at those renovation projects to see if you need to initiate a claim. As I said, seek guidance from a construction lawyer and then an engineer if you believe that there may be defects that are not readily observable. Here's some resources here at Becker that can help you. Obviously, our website, also the Florida Condo HOA log and our legislative guide. I'm going to also answer some questions. I'm going to put my email on the screen so that you can get my email and send me any questions that you may have and reach out. But this bill is a very bad bill. And one of the things that we are trying to get completed through a glitch bill next year is some sort of a savings clause that would basically toll the running of the statute of limitations and the statute of repose for both condominium associations, co-ops, and then also HOAs. So this is something that we're already talking with legislators about in Tallahassee. If you have relationships with your legislators, please do the same. We think that it's important with this constantly eroding timeline to file a construction defect claim. We believe that at the least, community associations need to be protected because of the ability of a developer to hold on to a project for a certain number of years. And to answer that question, how long can a developer hold on to a project, an HOA, or a condominium? Interestingly enough, they can hold on to a condominium for 7 years before they have to turn it over. So, is it a coincidence that the statute of repose lines up with that 7-year period? I don't think so. I think these developers and their lobbyists are very, very smart, and they knew exactly what they were doing. So we're hoping that we can call on the better angels with these legislators and that they will see the problem that's been created for community associations in Florida, and the fact that a condominium could literally be turned over to its owners, and the association would have no cause of action for construction defects against the developer or the contractor that built the place. It can be even worse for a HOA. Many of you that live in HOAs right now, you may know that your community took 7, 8, 9 years to turn over from developer control, just because of the size of the community or the number of phases and neighborhoods that were being built. And so it's an even worse situation for HOAs, because there's no limit on how long a developer can hold on to the board of directors and control the board of directors for an HOA. As I said, I was going to put my email on the screen, and I have done so. So please, if you have questions or concerns about the presentation, please email me and let me know. I'm going to now answer some questions that were sent in previously from some of you. All right, we've got Brenda, who is in Boynton Beach. She asked the question, will the DeSantis law override 718, 719, and 720 laws? So she's talking about Chapter 718, which is the Condominium Act, Chapter 719, which is the Co-op Act, and Chapter 720, which is the HOA Act. The answer is yes. So of those 3 statutory provisions, the only one that has any sort of a tolling provision within it is Chapter 718, and that is only as to the statute of limitations. So for a condominium, the statute of limitations is tolled for any action against the developer or the contractor or anybody else for construction defects until turnover. However, the statute of repose is not included in that tolling provision in Chapter 718. So the problem is that you're going to have communities where you're turned over and the statute of limitations has not run, but the statute of repose may have run years before. And so it is this problem that we're going to try to fix again with the glitch bill next year with the Florida legislature, and we hope that moves smoothly. 719 and 720 have no tolling provision. It does not exist. It never existed. And so that's an issue that is now compounded by this new law. And so we're going to seek to have the tolling provisions added to those 2 provisions as well. So Brenda, thank you so much for that question. We've also got a question from Dean, and Dean's question is the condo information the same for co-ops? The answer is yes. This new law, Senate Bill 360, applies to co-ops, HOAs, and condominium associations. So all of them are unfortunately affected the same. Several folks from co-ops here. How much of this will apply to co-ops? Again, it's the same for co-ops, condos, and HOAs. The statute of repose has been reduced, and the building code cause of action has been watered down for all of it. All right, we've got Doris in Ponce Inlet. She says, my 25-year-old building is undergoing a restoration. Do we have the ability for a construction defect suit back against the original developer? So with a 25-year-old building, you're not going to be able to sue the original developer even under the old law, because the old law had 10 years. You will be able to go after the contractor that is undertaking these building restorations if they do so in a negligent manner and there are defects. So again, it goes back to what I talked about before. When you sign that contract, please have your management company and your board members put on their calendars 7 years from there, probably 6 years from there, so that you can start to take a good look at those renovations and make sure that there are no defects. If so, you'll need to bring a claim prior to that 7 years running. She follows up with this question: what if something the current restoration contractor does goes wrong? So again, I answered that question. You're going to have a cause of action, but you're going to have to be very vigilant under this new law with the 7 years, because it narrows that window that you used to have. You know, when it was 15 years, it was a nice window. 10 years was a little harder, but now 7 years is going to be very difficult for associations. All right, we've got Robert in Naples. He asked this question: does this new law affect the duration of warranties on new buildings? Yes, the answer is yes. So, you know, in Florida, there is a statutory warranty that is given under section 718-203. It is a very consumer-oriented warranty. And basically, the warranty that's given is from the developer, the contractor, and the subcontractors to the association for any defective conditions that are discovered after turnover. I mentioned the tolling provision that's included in the Condominium Act as well. So that warranty doesn't even begin to, the statute of limitations on it doesn't even begin to run until turnover. The problem is that now the statute of repose is possibly going to expire prior to some condominium associations even turning over, or maybe soon thereafter, maybe just a few months after turnover, before the board can even get its bearings and, you know, figure out what's going on and hire a forensic engineer or architect. So it will affect these warranties. The warranties will evaporate when the statute of repose runs. So it's not a good thing, I'll tell you that. We've got Melanie, who is at Venetia Condominium. She says, what happens with our reserves and if we don't have enough money in them? So, you know, with a condominium, you've got statutory reserves. One of the nice things that has changed with the condo safety bill is that the developer is no longer able to waive those 2 years of reserves prior to turnover. And so condominium associations are going to start out in a good position with those reserves funded. So that is a good thing. Not really the subject matter of this presentation, but I did highlight it and I wanted to talk about it because with HOAs, there is no statutory requirement that a developer fund reserves for an HOA. And so we are seeing community associations, HOAs, that are turned over with private roads, private drainage, millions and millions of dollars worth of privately owned infrastructure, clubhouses, swimming pools, that have to be maintained by the HOA and of course the owners who pay those assessments, and they're being turned over with zero reserves from the developer. There was actually a change in 2007 that made reserves mandatory. Once the developer began to fund those reserves, they had to continue all the way until turnover unless the membership waived the funding of those reserves. Well, guess what? Along came the developer lobby. They lobbied a few years back, the Florida legislature, and they removed that requirement for developers. And so for the last few years, we've been seeing community associations that have seen developers take advantage of that law and turn over their community associations with no reserves. It just compounds what we're talking about today with these construction defects, because you have communities, you have HOAs that are being turned over with no reserves to make any repairs, construction defects, and then no cause of action against the developer or the contractor to repair those contractors. Guess what? Guess where the money comes from then? It comes from special assessments to the owners. So owners are going to be faced with thousands and thousands of dollars in special assessments to pay to rectify construction defects that are the fault of the developer and the contractors. So I did want to highlight the question. I thought it was a good one because of how this law, compounded with prior changes to Chapter 720, have really put HOAs in a bad situation. So we've got Ed, who is in Destin, Florida. Beautiful beaches there. Thanks for your question, Ed. What are the means for which to recover a claim beyond the statute of limitations when the damage is identical in multiple buildings? And during such time, if the statute of limitations, the developer managed the association. So great question. This is exactly what we're talking about here. So if you've got multiple buildings and you've got the exact same defects, if you are a townhome HOA or a condominium that has several buildings, you are literally going to have a situation where the HOA board is turned over, and they go to hire an engineer and or a forensic architect and also hire a construction defect lawyer, and they're going to come back and they're going to say, sorry, your first 6 buildings have fallen off of the statute of limitations and the statute of repose, so you have no claim as to those. We can bring a claim as to the last 6, but the first 6, sorry, you're out of luck. And your question is a good one, because typically the same contractor built those buildings and used the same subcontractors. So the same defect is in each of the buildings, has each of the same problems. Sometimes it's stucco, sometimes it's bad windows. We have a community that we're helping now where all of a certain type of window was installed upside down. So obviously that's a defect. But you're going to have situations where buildings have the exact same defect. Some are going to be within the statute of repose and some are going to be outside of the statute of repose. So it's one of the real problems with this bill. He also asked a question, what about when the developer was managing the association? Those tips that I gave you before about emailing the property manager about defects that you see, emailing the pre-turnover board members who are appointed by the developer about those defects. Those are going to protect the association and you later on if the developer holds on to everything and turns it over with the statute of repose run. And so, I can't go into a lot of detail here with the time constraints that we have, but talk with a construction lawyer about that, and they can tell you how doing those things is going to protect you and the association later on, and perhaps keep a viable claim against the developer going. All right, we've got Linda in Palm Beach. She asked this question: if sliding glass doors or frames are removed and damaged in the process of restoration, who is responsible for paying for the replacement and installation of the new ones? So this is a perfect example of a defect. So they have taken something, they're supposed to be renovating, they're supposed to be making it better, and in some aspects they actually make it worse. They actually create defects to those buildings and units. That's going to be on the renovation contractor or subcontractor. So you have a cause of action, and again, look at the contract date and then be careful about calculating the deadlines for when you have to bring those construction defect claims. All right, we've got Marcia in Bonita Springs, and she asked this question: how does this affect new construction? Again, with new construction, that was the first portion of the presentation. And with new construction, the real problem for condominiums, co-ops, and HOAs is that the developer can hold on to the association and prevent the association from actually filing a lawsuit to recover construction defect damages, prior to turnover. In fact, interestingly enough, if you read the way that Chapter 718, Chapter 720, and the Co-op Act are written, it isn't until turnover from developer control that the association even has the ability or the standing to bring a construction defect claim. And so I think this new law really affects new construction, new communities, new HOAs, and new condominiums worse than it really does anybody else. Let's see, we've got Josh Walsh in St. Pete. I'm aware of the legislation pertaining to condos. What about HOAs in 720? We talked about that. It's possibly worse for HOAs that have private infrastructure, swimming pools, private roads, private drainage, things like that, because of the ability of the developer to hold on indefinitely to an HOA. But I put some tips in there about how you can protect the association. So please follow those and reach out to me or a board certified construction lawyer if you have questions about that. So we're running up on our deadline, pardon the pun. So I appreciate everybody attending. We had a nice crowd here. This new law is unfortunate, but there are some ways to protect your association and protect yourself. Just make sure that you contact a board certified construction lawyer and ask them how they can help you specifically with your situation and your community, protect yourself against the running of the statute of limitations and statute are proposed for a construction defect. I really appreciate your time. Thank you.